I think if it's okay, we can go ahead and get started. So again, welcome to the In the Weeds presentation. If you have any questions throughout the webinar, please feel free to go ahead and put them in the chat box there, and we will make sure we can get to as many questions as we can. I want to first of all hope everyone and your families are doing well, given the current situation. And we also want to thank you and NCIA in particular for hosting us today to allow us to have a very pertinent and poignant discussion on political advocacy and campaign finance issues. And by way of background today, Nasaman is going to be presenting this webinar, and we are a California-based law firm with 8 offices, 5 in California and 3 others across the country. The firm has represented cannabis stakeholders for years, including cultivators, municipal governments, business entities, and the firm's addressed a multitude of issues in the area, including real estate issues, business entity formation issues, contractual agreements, licensing, and of course, political law, campaign finance, and advocacy issues. So today, I am joined by my panelists, Amber Maltby and Bill Powers. Amber has served in various legal roles to the California Cannabis Industry Association, and Bill is a former enforcement attorney with the Federal Election Commission and has also served in some other roles as well. Their bios can be found at nasaman.com. And again, we will address as many questions at the end, so please feel free to type them in the chat box as they come to you. So what do we mean by advocacy? Advocacy can take several forms. It can take, including these 3 listed on the screen before you, as well as some common tactics. These are the additional tactics, and we'll cover all 3 big main advocacy tactics, and we'll also cover all the sort of sub-tactics, if you will. And leading this off, we're going to go into electoral activity first. And with electoral activity, we're going to have Bill Powers discuss that, especially with his background from the Federal Election Commission, and really what it means to have electoral advocacy and some of the types of issues that are definitely going to come up or that you should be aware of as we engage in this very politically active time of the year. So Bill, let me go ahead and turn that over to you.
Thanks, Michael, and thank you everyone for joining us for this. We certainly want to start off by recognizing that campaigns and electoral campaigns have been disrupted by the coronavirus pandemic. We should be right in the heart of primary season with elections at the federal, state, and local level, but much like everything else in our lives, that the elections have been somewhat disrupted. But this is an important, particularly electing candidates is an important aspect of advocacy. And as Michael mentioned, I worked for almost 10 years at the Federal Election Commission, and I've also been in private practice since 2016, dealing with state, local, and federal issues. So when we're talking about advocacy and supporting candidates, what do we mean? It can take a lot of different shapes. You can, give money to a candidate, which might be the most common means of people supporting candidates, but you can also engage in other types of activity, including volunteer activity, which could include hosting fundraisers. And, in today's social distancing environment, that might not include in-person fundraisers anymore, or for a period of time. But we might be going, online and doing more of that. There's other things that you might be engaged in. It could be, you could do independent expenditures, which means advocating whether that for a particular candidate, it could be, which would be separate from the campaign. You could be doing it through a number of different means. You could be doing it personally. You could be doing it through a company where that's permitted. And you could be doing that through different types of organizations like nonprofits or PACs. You know, one thing to think about when you're supporting candidates is, are you involved with a campaign, or are you doing something outside of the campaign? A lot of areas, most states, and definitely at the federal level, have rules regarding coordination and how much interaction the campaign can have with outside groups, and there are limits on that, and there are laws and rules in place. So as you're thinking about your advocacy efforts, once elections resume and perhaps back in full throttle, you just want to think about what are the different ways you're engaging with candidates at the state, local, and federal level. And as we go on to the next slide, I want to focus on PACs, or political committees, which is one way of making contributions and raising funds that could be given to a candidate. So some of you all might be familiar with PACs. You might have a company might have a PAC, or you might be giving to a political committee that's independent of a company and just supporting various candidates, or you might even be involved with a trade association PAC. And what are the things that you should be cognizant of when you're raising money, not just giving money or writing a check to a candidate, but raising money through a PAC. And first of all, as we mentioned a little bit, there are some activities that don't rise to the level of a contribution, and don't have to be reported or tracked. That includes general volunteer activity for candidates. Generally, there are, if you have a company and you're communicating with your own employee, or an organization, you're communicating with your own members, that's permissible, but you may have to report some of that activity depending on what you're doing. But I guess I wanted to give one kind of example of why fundraising can be tricky, particularly if you have a small business or an entity that might be new to politics, because of just the way your business is run. You might not have supported candidates before, but now for whatever reason you're getting more involved. And this is a case that came out of the 2008 election that was before the Federal Election Commission, and it involved a owner of a gym who had a couple of different locations, actually here in Washington, D.C. The owner wanted to support the Obama campaign and put together a fundraiser, and kind of did it on his own. And under the federal election rules, you cannot give corporate contributions. A corporation cannot directly give money or support money for federal candidate. And what the mistake that the gym owner made, not having really gotten too involved in politics before, was simply sending out the invitation to the fundraiser to the corporate email list, and spending a couple $100 on I think literally beer and wine to have at this fundraiser. And this person who was new to elections, new to campaign rules, probably didn't think twice about it, because they were the CEO and own this company, and was simply making it available for a fundraiser. But under FEC rules, that type of conduct rose to the level of being a contribution. And because the value of the email list and the few $100s worth of beer and wine for the event were paid for with corporate dollars, it was considered a violation of the federal campaign laws. So that's one example. If you're starting to support candidates, you just want to be very careful and check with the rules to make sure that you aren't either personally running up against things like contribution limits or making a contribution using corporate resources as opposed to individual resources. And then, getting to the next slide, particularly as we all are working from home and dealing with social distancing and stay-at-home orders, more and more candidate support is going to be coming in the form of social media and the form of internet communications. And we're seeing the presidential campaigns, Joe Biden in his basement studio, and other other candidates probably following suit, where they're doing campaigning almost exclusively over the internet while we're dealing with the COVID-19 response. And just a few quick notes on this. At the federal level, there are rules related to what sort of social media advertising gets reported and counts and what doesn't, but the rules are from 2006. So basically, the only thing that's covered by the FEC rules are paid communications on the internet that are placed on another person's website for a fee. So, paid Facebook advertising, other social media advertising, banner ads, that type of thing. But it doesn't cover organic social media. The FEC has been grappling with this since at least 2010, trying to figure out how to deal with social media, and it just has not been able to come up with rules. So the main takeaway here is actually not to worry so much about federal rules if you want to support a federal candidate, unless you're doing paid advertising. The main concern here is what Facebook, Twitter, and the other social media platforms have put into their terms of service and their requirements for identifying and reporting the source of any advertisements that might actually indicate support for a candidate. So with that, I want to turn it over to my partner, Amber Malpe. It's based out of California. Before the COVID-19 break, California had a primary in early March. And Amber brings a lot of frontline experience from those races as well as some others across the country, and is going to touch a little bit on some best practices.
Great, thank you, Bill. And I'll start by saying that here in California, we've been really grateful that our primary election happened before things really went south with COVID-19. So, we got our local campaigns got a little bit of a break with that. But so what I want to talk about here is what are the best practices and red flags for people and companies to look out for once you made the decision that you want to support a candidate. So the first thing to keep in mind is that the patchwork of rules is extremely varied. So rules that apply to federal candidates are different than the rules that apply at the state level. All 50 states have their own campaign finance rules, which govern whether and which types of contributions are permissible. And then even local jurisdictions, city councils, municipalities, oftentimes have their own campaign finance rules. And so the very first thing that you need to do when you've made a decision there's a candidate that you want to support is understand, are you allowed to make that contribution? And so beneath that, the next layer of that is looking at who is the source of the contribution. Do you want the contributor to be the company, or do you want the contributor to be individuals within the company, normally officers, high-level management? And in that regard, one of the things that we've noticed in helping companies navigate their contribution programs is making sure that you're aware of any issues in terms of aggregation of contributions. So a lot of times throwing support behind a candidate can be really important for a company. And so the company will want to make contributions from its general treasury if it can, but then employees may also want to make contributions. In a lot of jurisdictions where there are contribution limits, the contributions will be aggregated between the company and owners of the company, for example. And so we recommend developing a tracking system so that anybody making contributions to candidates, collectively, you're able to make sure that you're not accidentally running afoul of any limits or making impermissible corporate contributions. And that's particularly relevant if you have people who have corporate credit cards that they're not making contributions on a company credit card when they really ought to be making contributions from their personal accounts. So in addition to making, I'm sorry, Michael, can you go to the next slide? The other big consideration in terms of whether or not your company can make contributions is in states like New Jersey and Maryland, where there are what are known as pay-to-play restrictions, which essentially ties contributions to state contracts. So in some places, if your company has a contract with a state agency or a local jurisdiction, then your company might be a prohibited donor. Or there may be some time restrictions when it can make a contribution. One of the sort of big picture ways that we advise our clients is always come to the table with a do good, not harm philosophy. And so, knowing and do good, not just for the candidate that you want to support, but also for your own company's reputation. And one frontline example that I can give from the California March primary election, we worked with there was a city council race where two members of the city council really became targets of a proxy war between pro-cannabis and anti-cannabis interests. And so there was hundreds of thousands of dollars spent in independent expenditures trying to influence this election. And the side that was the opposite to our client, they sent out lots of mail pieces attacking these two city council candidates. And we immediately identified that the mail didn't have the proper disclaimer requirements. So they were doing independent expenditures, not in support of the laws, and so we turned it over to the California's campaign finance regulator, the Fair Political Practices Commission, and they opened an investigation. So in that regard, we were pleased because it was our client's opponent that we were able to get in hot water with the campaign finance regulator. But you never want that to be you, and so you want to. Again, once you identify that there's a candidate or a group of candidates that you want to support, you want to make sure that you're looking at the rules of the road so that you're doing that good and not harm.
Thank you, Amber. And I want to indicate that we're about to move into our second phase of ballot measures. But before that, I just wanted to remind everybody, if you have questions, to please use the chat box. I know that somebody probably has some questions out there about, can we have a candidate in our dispensary? Maybe a question around, can I forward a fundraising email to my coworkers using my work address? Things of that sort. We would welcome any kind of questions in that regard. And now turning to the second bucket, if you will, of ballot measures. We will discuss the advocacy tactic of ballot measures, and we know that this has been a popular avenue with various cannabis stakeholders at the state level. And Amber will guide us through the ballot measure process and some of the considerations and concerns through this process. So let me turn it back over to you, Amber.
Thank you, Michael. So switching gears, supporting candidates has its own set of traps for the unwary, so to speak. Supporting ballot measures is another avenue, as Michael mentioned, has been very popular and very effective means of changing policies at the state and local level in terms of cannabis reform policies. So what a ballot measure is it is an issue, so a change in the law, whether it's a state constitution or a statutory change or something at the local level like a local ordinance, but it's voted on directly by the people and generally does not have to go through the legislature. So, you know, we think of it as people-driven politics, and they've been particularly effective when dealing with non-responsive legislatures and on all sorts of reforms. It's essentially a way, you know, when the legislature is not going with the will of the people to get around them. One of the key characteristics of a ballot measure is that because it is considered an issue, essentially, there's no contribution limit and there's no source restriction, meaning that whether you want to make a contribution to a ballot measure committee through your company or through individuals or a combination, all of those restrictions that we talked about on the candidate side don't apply. The only exception to that is foreign nationals are prohibited from engaging in U.S. elections. So you would need your U.S.-based company to make the donation. Similar to supporting a candidate, there are a variety of ways to support a ballot measure. Of course, there's always the opportunity to volunteer. Making direct contributions to a ballot measure committee is an easy way to support one. And one thing that we see frequently, statewide ballot measures are often multi-million-dollar enterprises that have, you know, a 1 to 2 year life. So they tend to operate like small businesses for the period of time that they're in operation. And so they often formalize a government structure so that major donors serve on the steering committee and help with some of the key strategic decisions. So that's another unique way that a company can support a ballot measure. But overall, ballot measures really are one of the most promising ways to move policy forward. We have to take a step back right now, though, because we are in the world of COVID-19, and so a number of states have measures, you know, that have already collected enough signatures. One of the requirements to get a proposed measure on the ballot is a minimum signature requirement, meaning a minimum number of people who sign on and say they want to see the measure on the ballot. It's usually about 5% of the people who voted in the last general election. And the window to collect those signatures in a lot of times is the April, May, June months that we're coming up on right now. So for those ballot measures that have already collected enough signatures, they're fine. What we're seeing is a lot of measures have really had to put their effort on hold because of social signature gathering really can't happen right now. And so a lot of campaigns are looking at 21, 22. So just something for you all to be aware of in the overall 2020 ballot measure environment. And you can go to the next slide, please. So here we're shifting gears a little bit. Regardless of whether you're supporting candidates or ballot measures, if your company or you as an individual or a group of individuals are raising money or spending money in the political process, there is a very good chance that you will have your own compliance requirements depending on the jurisdictions where you're engaging in that political activity. So what this means is it might be possible that you or your company has to register with a local elections official or a local campaign finance official and register campaign finance reports, letting the campaign filing official know who it is you're supporting, who you're spending your money on. And so we have a sort of checklist of questions that you want to go through. And again, these are things that you should do before you engage in political activity, because tripping up any one of these things could have the negative consequence of you or your company having a late filing, for example, not even being aware that you had it, and then getting penalized with a monetary fine or a public admonishment of some sort. So you want to look at whether or not you have to register with any agency if you're making the contribution or the independent expenditure. A particular concern for nonprofits is whether or not your donors will have to be disclosed. In a lot of jurisdictions, if you're making contributions over a certain amount to ballot measures or candidates, you'll be required to disclose some or sometimes all of your donors. And if your donors have an expectation of privacy, that can be bad for your member relations. And then, once you find out that you do have to register, you have to make sure that you're following whichever filing schedule applies to the local jurisdiction. And then other considerations applies to both candidates and ballot measures is the disclaimer requirements around advertisements. So there's usually two types of advertisements that we're talking about here. One is if you or your company decides to independently do a political communication supporting or opposing a candidate or ballot measure, what Bill was talking about earlier in the presentation, this is something that you do generally outside of the campaign or independent of the campaign. And then the other type of advertisement we're talking about is if a political action committee that you or your company donates to does paid political communication supporting or opposing a candidate. And the key considerations for you here is whether or not the name of your company or officers within your company will be required to be included as a paid for by donor on the political communication. So for example, in California, if a donor makes $50,000 or more in contributions to a PAC, and that PAC turns around and does an independent expenditure, then on that independent expenditure communication, it will say paid for by that donor $50,000. And so, you want to be aware if you have sensitivity about your company being on, mail pieces going into, voters' homes, something to take into consideration. And then on the other side is if you're doing those direct communications, will your name need to be on the mail piece as a paid for by, or as part of a paid for by statement? And if so, you want to make sure that you're complying with that. And then finally, again, going back to the COVID-19 era that we're in, social media is going to be more popular than ever, we think. But even before this, state agencies and regulators, including the FEC, have been really interested in social media disclaimers and, how do we ensure transparency about who is paying for digital ads. The Fair Political Practices Commission just started a digital transparency task force. The State of Washington Public Disclosure Commission also recently held a meeting of several state agencies just to look at this issue. And so if you or your company are using social media for communications, you want to make sure you're always checking in on what the rules are, because that is a constantly evolving area.
Thank you, Amber. Also, just to point out again, to better visualize the ways ballot measures are being used in the industry, this map shows how coast to coast ballot measures are impacting the cannabis industry in states like Arizona, Florida, Missouri, New Jersey, and the list goes on. And as Forbes magazine stated, 2020 could be a big year for the cannabis industry. I know that there may be, again, some questions such as, can I write a campaign check to support a ballot measure from my corporate account? Make sure you're using the chat feature and ask your questions if you have questions. And we will turn to the third bucket now. We're going to turn to our lobbying tactic, and Bill Powers is going to lead us through this discussion. Bill, I'm going to turn that over to you.
Thanks, Michael. One thing about ballot measures is that first of all, they don't exist at the federal level, and only about half the states have an opportunity to pass a law through a ballot measure. So that leaves us at the federal level, and in a lot of the states, if we want to make changes to the laws that affect our businesses and our communities, that we have to go through the Statehouse or through Congress. And so you might have to engage as part of your advocacy in lobbying. And that can mean a lot of different things, but I want to start with the federal lobbying rules, the Lobbying Disclosure Act. And we're going to touch on that briefly. And also, just like the campaign finance rules differ from state to state and from jurisdiction to jurisdiction, so do the lobbying rules. So just because something might not trigger any sort of disclosure or compliance at the federal level doesn't mean that if you do it at the state or local level, the same sort of communication with your state legislator or your city council member, that might not trigger something at that level. So we're just going to go over a few things about federal advocacy, federal lobbying, but the main goal in this discussion is just to kind of give you an idea of what sort of activities, if you engage in, might trigger a legal requirement. And we'll start with the definition of what is a lobbyist at the federal level under the Lobbying Disclosure Act. There's three components to the definition, and you have to meet all three. So you may be engaged in what you consider lobbying, or you might be involved in like a Hill Day, but that doesn't mean that you are going to have to register as a lobbyist. But these are just things to keep in mind when you're engaging in advocacy, either on your own behalf, as part of a coalition, on behalf of your company, or part of a broader effort. And one thing just to kind of flag here at the beginning of this discussion is when we think about, I mentioned Hill Days, I mentioned things in Washington, D.C., but you may have contacts with federal office holders and their staff in their district offices. So try to keep that in mind too. It's about the type of official or staff member that you're contacting, and not just about the location. So under the LDA, a lobbyist is any individual who is retained or employed for compensation. That's the first part. So you have to actually be paid for what you're doing. That could either be directly paid, like you think of for traditional lobbyists are paid to go and lobby, or that could be part of your job or part of your compensation for your company. So if you receive money for doing that, you could trigger the first requirement. But under the second requirement, you have to have more than one lobbying contact. And what does that mean? What's a lobbying contact? Basically, at the federal level, it's any contact with somebody who works for Congress, and that includes members of Congress and senators and all their staff, both here in Washington, D.C., and also in their district offices. And then there's also a whole series of executive branch officials who are covered, mostly political appointees, but you still have to be aware of who they are, and there's a kind of an analysis that we as lawyers do often if they're officials that you might be talking to. And then there's under this second prong, when you're thinking about more than one contact, a question we often get is somebody who said, oh yeah, I have a lobby meeting, but I called the office beforehand to make sure it's on. Does that count as my second one? Does that make it does that mean I have to register as a lobbyist? There are things such as administrative contacts or checking on the status of a bill that aren't going to count. So again, these just an overview of things to think about. And the third category, which I just mentioned briefly, is you have to be doing at least 20% of your time on this activity. So if you're only doing a little bit of time, then it's not going to trigger lobbying registration at the federal level. And talking about tracking time, there are different things that you need to consider. The first being, how much of your time not just is spent talking directly to members of Congress or their staff or the federal executives, but also, the time spent preparing for it counts as well. And just quickly, a few things to cover, as you're planning your legislative advocacy, things that we should think about here are, if you are a nonprofit or you work with a nonprofit, you might have a different definition of lobbying. And so there's an IRS definition and there's a Lobbying Disclosure Act definition. So that's one area where we get a lot of questions as lawyers. I already mentioned the overhead costs and the prep time related to lobbying. And also thinking about, if you're thinking about doing a lot, lobbying activity, if you're a company and you want to hire a lobbyist here in DC, that lobbyist files the registration, but they disclose you as a client. So it's a contract lobbyist, and that's a different sort of registration than if you as a company have a paid lobbyist that is your employee who meets those three criteria, then you would register and then list your lobbyist. So just the thing to keep in mind is at the federal level and at the state and local level that we'll get into for in a minute here, that there's going to be reporting required as part of your lobbying activity. And with that, I think I'm ready to hand it over to Amber for the state and local portion of the lobbying presentation.
Thank you, Bill. So similar to the campaign finance legal matrix that we discussed earlier, lobbying takes many forms depending on the state or local jurisdiction where you're engaging in the activity. So Bill just went over in some detail what would be considered lobbying at the federal level. You would have to do the same analysis at the state and local level to determine if your activity qualifies one of your employees as a lobbyist, for example, or if somebody that you're hiring to influence legislative policy would qualify as a lobbyist. Although the general principles apply, which are where you would want to pause and say, okay, maybe we need to see if there's a lobbying issue here. Is there direct contact or communications being made to somebody who's in an elected position or in a non-elected administrative position, for example, somebody who works within the executive branch of a state government. And, is there some sort of compensation involved for making those contacts, including somebody who's spending their compensated time as an in-house employee? So, you always want to check and see if your activity is covered, and if there's any corresponding registration or reporting that may go along with it. One of the sort of key differences between federal lobbying and state and local lobbying, especially at the local level, is that the types of influencing that you might be doing on behalf of your company in front of or towards an elected official could be very different, because you're not necessarily influencing, like, for example, a city council, again, or a municipality, like a county board of county supervisors. In front of those types of entities, there's any number of things that you might have an interest in. It could have to do a zoning issue, seeking a permit or an entitlement for use. And those things, those are the types of things that you may think of as part of your business plan, not part of your lobbying. You might not think of them as lobbying because they're not policies, they're not changes to ordinances. They're unique to you and your company and what you're trying to accomplish as a business. And for a lot of local jurisdictions, those types of contacts should influence administrative actions like licenses and permits actually are covered by the lobby ordinances as well. So when you're, especially at the local level and the state level, you just make sure that you're thinking not just, am I trying to influence or change some sort of policy through, legislation or an ordinance, but am I trying to influence a decision that really only has a direct impact on me and my company, but it is an elected official who's making that decision. So we just wanted to get you all thinking about that. And again, the consequences of qualifying as a lobbyist or hiring somebody who qualifies as a lobbyist is you may have to register with a local official and file reports disclosing how much money you're spending on that lobbying effort. So something to be aware of. And now I'm turning it back over to Bill to talk about public education in this arena.
Thanks, Amber. Just to quickly note, there's a kind of a fine line between what's advocacy that triggers these legal reporting requirements and restrictions, and what is general outreach in your community, public education. And we just wanted to highlight that, your advocacy efforts may include some public education components to it that don't trigger any of these laws, but are still an important part of a holistic advocacy effort. And so we'll just, leave those issues up there for you to think about, if you're having, forums with candidates or office holders. There might be some issues, and even if it doesn't trigger something, you still might want to think about, how does this fit into the rest of our advocacy approach? And speaking of, trying to stay on the right side of the line of that, I'm going to end and hand it back to Amber for a quick note on gifts.
Thank you. So another thing for you to think about is, when you're interfacing with elected officials, oftentimes it's not under the guise of directly influencing anything particular. Oftentimes it's just, getting to know the person, but also wanting the person to get to know you as well. And this oftentimes happens over, things like meals or coffee, or in the alternative mentioned forums. Oftentimes you want elected officials, particularly those who've been champions for your issues, to come and speak at your events. You may have, conferences, for example, and forums, and as a part of those events, as a thank you, you're providing the elected officials with, maybe a plaque or, inviting them to stay for a meal. And so those all are innocuous encounters, but many elected officials and public employees at the state and local level, and also at the federal level, are subject to gift limitations. And this can take the form of a limit on the amount of gifts that they can receive from a particular source, or going back to the source restrictions we talked about earlier, if an entity or individual is considered to be interested in an official decision that the elected or public employee can make that could impact that company, then the gift may be prohibited outright. And so, we always say, even a cup of coffee can be a gift. Again, one of the themes I think we tried to put forward throughout this presentation is your goal with your advocacy always is to do good and not harm. And, this is an area that we find, can easily be tripped over because the rules are so varied and tend to be pretty nuanced depending on the jurisdiction. So again, another way that you might be interfacing with elected officials and public employees is, in these more benign and formal settings. So just be aware about whether or not you might be making a gift.
Thank you, Amber, and thank you, Bill. So we're going to turn it over for some questions. We've received a few, and one of them that I know that, Bill, you've seen several times in your life, but the question is, can I forward a candidate's fundraising email to my coworkers on my work email? Bill, I'll turn that over to you, I think.
Yeah, thanks, Michael. Yeah, that's a good one, and it comes from the, kind of comes in play with the case I was talking about with the gym and sending the fundraiser invite to an entire corporation's email list. So, if you're just forwarding, and this is just with respect to the federal rules, if you're just forwarding it to your kind of friends and family, as an FYI, or hey, I'm going to this, do you want to come? That is usually okay. There's a kind of what they call a de minimis exception. If it's just a kind of few people, if it's not a full corporate email list, that's one thing. If you're going to send it to all of your contacts in your Outlook or your Gmail, I would recommend forward it to your personal account and then use that to forward it along, just to be safe, just to make sure you're not creating any problems. The other thing you want to be careful of with using corporate resources is if you're the founder of your company, the CEO, and you send it to your subordinate employees, there are rules against coercing political activity and political contributions from the Federal Election Commission, and most states have them as well. So you just want to be careful that you're not tripping those as well. So the kind of best practice is to do it from your personal account, but if you happen to forward something around on a lower level, it's not going to rise to the level of an issue at the FEC. So thanks for that question.
Sure, thank you, Bill. And we have another question here too about can I write a check to support a ballot measure from my business account? And I think Amber would be prepared to answer that question. So I'll turn it over to Amber for that one.
Yes, thank you. So one of the, as a compliance attorney, one of the things I like the most about ballot measure committees is that almost anybody can make a contribution to a ballot measure committee. So, it's very permissible. So yes, you can make a contribution from your business account to a ballot measure committee. What you can't do is write If your company is foreign owned, then you need to do it through a US based subsidiary. But other than that, there's really no restrictions.
Okay. I know we have a few other questions, but I know that we're also getting a little long in our presentation, so we'll keep this. I think we're going to go ahead and wrap it up here. But before we do that, I want to thank everyone for attending and joining. I want to thank our panelists, Amber Mulpey and Bill Powers, for joining as well. And I really want to give a special thanks to NCIA for hosting us and providing this opportunity. And for anybody that's interested, the webinar will be available probably in a few days to a week if you'd like to watch it offline. And everyone, please take care. And if you have any questions, specific questions that you think Bill or Amber could answer or that I can answer, feel free to get in touch. We're always happy to talk with folks. Everyone take care, and we'll talk with you soon. Thank you.